Hello, welcome to Trump 47 Watch. Today's episode focuses on presidential powers on dismantling federal unions based on a federal court of appeals ruling that upheld the president's authority to restrict the application of labor rights to agencies in the federal government that have a national security mission. I'm Eric Masters, professor of business, commentator, podcaster, and author. You can find me at my YouTube channel. Today's date is August the 5th, 2025. To go back a little bit to refresh your memory, the president issued Executive Order 14251 on March 27, 2025, titled Exclusions from Federal Labor Management Relations Programs. What this order basically did is said that the agencies and sub-agencies enumerated in the order were exempt from protection under the Federal Service Labor Management Relations Statute enacted in 1978 if they have, according to a presidential determination, a primary function of intelligence, counterintelligence, investigative, or national security work. It went on to say that with respect to employees and agencies or subdivisions that were enumerated, that were previously part of a bargaining unit but have been exempted under the order, each applicable agency shall, upon termination of the applicable collective bargaining agreement, reassign any such employees who performed non-agency business pursuant to performing solely agency business, and terminate agency participation in any proceeding relevant to grievances. A compilation of the agencies affected by this in part shows that close to 1 million bargaining unit employees represented by unions in the federal service have been excluded from protection under the Federal Service Labor Management Relations Statute based on the president's order. A case was filed by the American Federation of Government Employees et al. Versus Donald Trump et al. And the appellate court ruled that the government has shown that it is likely to succeed on the merits of a retaliation claim made by the union et al. Basically, that Trump was retaliating against them for taking strong stances against his positions on public policy in violation of their First Amendment rights. What the court said was, on its face, the executive order does not express any retaliatory animus. Instead, it conveys the president's determination that excluded agencies have primary functions implicating national security and cannot be subjected to the Federal Service Labor Management Relations Statute consistent with national security. The court went on to say that staying the injunction, district court had granted an injunction staying the president's order, will serve the public, and what this court did was stay the order of the injunction, was to say that this staying the injunction will serve the public interest by preserving the president's autonomy under a statute that expressly recognizes his national security expertise. Obviously, the court has decided that this will be determined on appeal that will eventually go to the Supreme Court, the merits of the case. But pending that appeal and its final determination by the Supreme Court, the president's order remains in effect. This is a little bit about myself, and you can find selected source links for information in this podcast. I hope you've enjoyed it. Stay tuned for more episodes updating you on Trump 47, particularly as they pertain to federal sector labor management relations and related issues. Thank you and have a good day.